Okay, there we are. All right. Hello, everybody. Welcome to our Fourth Amendment class, our May class, May the 3rd class on the Fourth Amendment. We are diving into the history of the Fourth Amendment, why we have it, what it means, and then also kind of looking at some historic cases over the past and kind of looking at the answer to this hypothetical, which is based on a real life case, Carpenter v. US, which is, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data and location information? So think about that. Think about why you think yes or no. What's your constitutional reason behind that? And to help us understand the Fourth Amendment today, I am Jenna. I am substitute moderating for Curry Sotner, but I am here with our Chief Content Officer, Tom Donnelly, who is going to kind of take us through this journey today. Hi, Tom.
Hey, Jenna, great to be here with everyone.
Absolutely. All right, so let's look at some of the, while you're kind of stewing on that hypothetical, let's look at some of the other big questions we're looking at today. Like I said, we're going to look at why the framers put the Fourth Amendment into the Bill of Rights, what the founding generation's kind of vision for the Fourth Amendment and its protections were, what against unreasonable searches and seizures. When does the Fourth Amendment allow the government to search and seize your property? When is a government search or seizure reasonable? That's a big part of those questions. And then how does the Supreme Court interpret the Fourth Amendment over time? How has it dealt with challenges of shaping the Fourth Amendment's meaning in light of new technologies? Another big thing with the Fourth Amendment, papers, houses, effects has changed that meaning over the past few years. But let's start, Tom, I think as we always do, with the words of the Fourth Amendment, right?
Absolutely, it's perfect. And it's very inspiring language. So I'll read it in full and then we'll break down some of the key parts of the text. So here's the Fourth Amendment: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So if we look at the text of the amendment here, it's possible to break it down into a couple of key components. First, what we see with the Fourth Amendment is the Fourth Amendment tells us what is protected. And that's it's persons, houses, papers, and effects. What do effects mean? Well, it's our stuff. I mean, it's a pretty broad term, but it's protecting our stuff. And what is it protected against? Unreasonable searches and seizures by the government. That's the core protection of the Fourth Amendment. It's against unreasonable search and seizures by the government. Who's the government in this context usually today? Well, it's usually police officers. And so in that sense, the Fourth Amendment is the amendment that in many cases most regulates our interactions with police officers as part of our daily lives. And then finally, the last thing that we see in the text of the Fourth Amendment is the warrant requirement. And we see this language about, a warrant may not issue except upon probable cause. And so what we're doing here is that the Fourth Amendment places restraints on the government anytime it searches or seizes a person. One of those things is often requiring a warrant, and it ensures that searches or seizures are generally cleared with a judge before government officials do that. Here, the key standard is probable cause, which means there has to be kind of a real reasonable suspicion connected to a particular person or a particular place. And it's also a reminder, finally, that a key part of the warrant requirement is that we're not just giving the government broad authority to rummage around everywhere and anything that could possibly have to do with a crime, but the warrant that they're getting from a judge has to really describe with particularity. It has to be specific about the person you're searching, the place you're searching, the things you're looking for. And this connects in many ways, Jenna, to the founding story we're going to talk about next, the story of James Otis.
Yeah, so I think that, the big question that we always ask with the Fourth Amendment is, can they do that? And so you kind of sum that up really well, which is, it depends. The Fourth Amendment does protect us, but there are those certain instances where there's those exceptions. And so kind of understanding what those exceptions are and when they apply, because when can we kind of have that reasonable level of privacy? That's kind of the key to understanding the Fourth Amendment. So some of these questions that you can kind of ask, can they do that? Can they not do that? Can police officers stop me on the street? Can they search my car, my desk, my nightstand? Can they look at who I've called? All of those questions are there. And the answer is, it depends, right? It depends on those, if they've met those requirements, right, Tom?
Yeah, so I mean, the big idea here, Jenna, that's really animating the Fourth Amendment is that before the government can search your home, seize your property, your stuff, it needs a good reason. Yep. It needs a good reason that's specific to you, specific to a particular crime, specific to a place, and specific to those things. So the government needs a good reason in order to search or seize our persons, houses, papers, or effects.
That's great. All right, you talked about James Otis, so let's get to him because this is a really cool story. So tell us about who's James Otis, and kind of what he was, against.
Yeah, so this is one of the key founding stories behind the Fourth Amendment. It would have been in the founders' minds as they were putting together the Fourth Amendment itself. The year 1761, so that's 15 years before the Declaration of Independence. We're in the city of Boston, so we're in colonial Boston. And as a result of the French and Indian War, the British Empire is looking to start to enforce anti-smuggling acts inside the colonies. So they've long had these laws on the books telling the colonists you can't smuggle. We have a lot of regulations of what goods that you're bringing in here. Why? Because the British Empire wants to collect taxes on those goods. But you know what? The British Empire had a lot of stuff going on. They didn't enforce these laws for a really long period of time. So the colonists basically smuggled whenever they wanted to, and these laws were virtually never enforced. But the British Empire, because of the wars it was fighting, it needed money. And so what it decided is, who has a lot of money? The American colonists do. And you know what? We have these laws against smuggling. Let's start enforcing them. And so to enforce these anti-smuggling laws, King George III used royal officials in the colonies to crack down on these smugglers with the use of what were known as writs of assistance. So these writs of assistance are really, they allow royal officials really free range to break into the homes or ships of colonists to search for evidence anytime, anywhere, and for any reason. So this is the absolute opposite of what we see in the Fourth Amendment, where we require specific details about what government officials are looking for. Here, these writs of assistance really allow royal officials to rummage around in the colonists' stuff. And so who are the smugglers? Frankly, they tend to be some of the most prominent figures in Boston. They're some of the biggest business people in Boston. And so these laws begin to get enforced. They bring their case to court, and their lawyer here is James Otis. And so James Otis, he argues before the Superior Court of Massachusetts in opposition to these writs of assistance. He says, look, these writs of assistance, what could go more against our rights as Englishmen, the English common law, and our natural rights than these writs of assistance, which allow people to really enter our homes, our businesses, our ships, look through our drawers, our stuff, without really any particular reason or particular suspicion to people. And so what Otis argues is that it violates a core principle, that a man's house is his castle, and whilst he is quiet, he is as well guarded as any prince in his castle. So Otis here is making a radical argument. He's saying Superior Court of Massachusetts, highest court in Massachusetts, say these writs of assistance are unconstitutional and that they violate natural law. In part, also what Otis was arguing is that these writs of assistance violate the rule of law itself, because a key thing here is that what he says is it is a power that places the liberty of every man in the hands of every petty officer. And when that happens, the rule of law breaks down. Our rights are in the hands of any minor British officials. And what could be a greater rights violation than that? In the end, Otis loses. So we still remember, but he was actually a loser in the case itself, but his memory was kept alive. In part, his memory was kept alive by the great John Adams, who is a young man. He loved James Otis. He admired James Otis. And he was sitting in that courtroom as Otis was making that argument. And he was sitting there just voraciously writing everything that Otis was saying. He was so excited. His mind was lit ablaze. And he would later look back on the arguments of James Otis and the writs of assistance, saying that there, the first scene of the first act of opposition to the arbitrary claims of Great Britain was born. Then and there, the child independence was born. What Adams is saying is that the American Revolution, to a certain extent, in the American mind, began with James Otis's argument. We also remember James Otis in this episode because it's such a key part of the American constitutional canon, and the Supreme Court has returned to it over and over again when explaining the purposes behind the Fourth Amendment. We'll see that when we get to the Olmstead case in a little bit, in the famous dissent of Justice Louis Brandeis. But just even a few years ago, in a landmark Fourth Amendment case known as Riley versus California involving cell phones, Chief Justice John Roberts would look back at James Otis and his arguments about the writs of assistance to explain the core purpose of the Fourth Amendment.
I love that. And I love that part of the story where he lost, but his arguments and kind of the fact that he lost and the fact that like that kind of added to what the colonists were arguing about, like had not only an impact on why we wanted to seek independence, but then what we wanted to do differently in the in the new Constitution, and then it was stuck so hard that like we wrote it right there into the Bill of Rights, and James Madison kind of kept that in mind. All right, so another thing we want to talk about are these like general warrants. Speaking of James Madison, so can you tell us a little bit about general warrants and how that leads into the story, and then we'll get into some of the cases.
Absolutely, yeah. So I mean, we had the James Otis episode. We write and ratify a new constitution, and then one of the first acts we do as a people is say, you know what we're going to do with that constitution? We're going to amend it. Right. And so we end up having our Bill of Rights. In the Bill of Rights is the Fourth Amendment that we read at the beginning. And, you know, as James Madison and the founding generation were putting together the Fourth Amendment, they were primarily concerned about general warrants. And so these are warrants that allowed royal officials to conduct broad searches without limits and gave them arbitrary powers to wield at disfavored colonists. So it very much connects with the arguments that James Otis was saying. And one of the core concerns here is that if you allow government officials to just really rummage around in all our stuff, get into our houses without any really good reasons, who are they going to go after most of the time? They're going to go after the rabble-rousers. They're going to go after the dissenters. They're going to go after the critics of the government, and that this would undermine our republic. And so it's no surprise that even before we had a Bill of Rights and even before we had a constitution, one of the core protections we see written into state constitutions is a protection against general warrants. Here's a famous one right here in the Virginia Declaration of Rights. It banned, quote unquote, general warrants whereby an officer or messenger may be commended to search suspected places without evidence of fact committed. And again, in the end, one of the core protections that we're trying to bring out with the Fourth Amendment is protecting against the dangers associated with the general warrants of just arbitrary searches done by the government with no particularized or specific reason or specific suspicion attached to them.
Yeah, so again, that big idea, before the government can search your things, they just need that good reason. Your things, your home, your possessions are, protected unless there's a reason. So let's get into those reasons. And I love this. You kind of spell this out in the briefing document so well, Tom, but there's kind of this basic framework for when the Supreme Court is approaching a Fourth Amendment case, kind of determining whether there was a violation of the search and seizure clause. There is this basic framework that they use. And so I would love for the students to kind of use the same framework as we talk about each one of these cases and make that decision and let it, for yourself, would you have considered this a violation? So let's talk about the framework and then dive into some of these cases.
We'll do the framework. So, I mean, the first thing the court asks in a Fourth Amendment case is, was there a search or seizure? So, entering someone's home to look for evidence, that's a search. Passively just looking someone in plain view in public, that's not a search. Okay. So when the government restrains someone or takes her property, there's a seizure. When the government doesn't, there isn't. Now, there are all sorts of really tight questions about whether there's been a search in many cases, and cases we're going to talk about are a lot about that question. But that's the most fundamental question. If there's no search, no seizure, there's no Fourth Amendment protection. There's no more work to be done. However, if there is a search or a seizure, then we have to ask that core question we see in the Fourth Amendment's text, which is, was that search or seizure reasonable? So generally, the police need to go to a judge and secure a warrant supported by probable cause before searching a home or property. But does a police officer always have to go and get a warrant? No. There are all sorts of exceptions the Supreme Court has recognized over time to the warrant requirement. So, the police may search you during an arrest. So if they're arresting you, they, generally speaking, don't need to get a warrant first. Or at a checkpoint, say a certain spot where maybe they're searching for drunk drivers, or when there's an imminent danger that someone might be hurt, a suspect might flee, or evidence might be destroyed, as in a drug raid. These are circumstances where really time is of the essence. And so we say that a warrant generally is not required in those particular cases. So these are exceptions to the warrant requirement. And then, if the police don't go to a judge and get a warrant first, the search or seizure is usually considered unreasonable. But again, we have to think about those exceptions and whether or not they apply. Finally, if there's a Fourth Amendment violation, what happens next? Well, generally, the courts are going to apply what's known as the exclusionary rule, which means that they're going to throw out evidence in a criminal trial that the police got by violating the Fourth Amendment. This is meant as a check on police abuses. So frankly, it sometimes means that, guilty suspects will go free because key evidence is excluded. So the exclusionary rule, though well established, is also very controversial. But again, there are also exceptions to the exclusionary rule. For instance, if police officers were acting in good faith or they made an honest mistake.
Mm-hmm. So if, just to clarify, if there was a search and it was considered an unreasonable search, but then when you get to the case, if that evidence is excluded, then there's no Fourth Amendment violation. Is that accurate because it's been excluded?
Well, I mean, I guess you could look at it that way. I mean, in the end, it's sort of like you have the case, there's a Fourth Amendment violation, you throw out the evidence, and then you sort of move on and hold the trial without that evidence.
Okay. All right, so let's look at some of these real life scenarios. And this is one of my favorite. We used to have this phone at the Constitution Center when we had our Prohibition exhibit. So it's such a cool case to look at. Olmstead versus the United States from 1928, so the height of Prohibition. Tell us about the facts of this case, Tom.
Yeah, so I mean, so far we've done the Fourth Amendment's text, we've done some history, we've done the general framework, and now we're going to look at how the Supreme Court has applied the Fourth Amendment over time to 3 different cases involving phones. And so one in the 1920s, one in the 1960s, one just a few years ago. So here in Olmstead, as Jenna said, it took place during the height of Prohibition in 1928. So federal officials, they're investigating Roy Olmstead. They think he's running an illegal liquor business. And so without a judicial warrant, they install wiretaps on the phone lines leading to his office, also to his home. And so one thing so they're able to listen to these conversations. One thing to keep in mind is, what is a wiretap? How do they work? So in that particular point, at that point in history, they actually have to drill into the lines of the phone. So it's a physical thing that's happening, and that's happening underground, and it's happening in the basement of Roy Olmstead, where he's leasing his office. And so the government does this, and they're able to listen to the suspect's phone conversations. The agents uncover evidence, and you know what? Olmstead was selling illegal liquor. But Olmstead argues that these wiretaps violated the Fourth Amendment. The federal agents, they didn't go and get a warrant. They just tapped these phone lines and listened into his conversation. In the end, the court ends up dividing 5-4, and Olmstead loses. And we see really a pair of dueling opinions that are really quite interesting. So the majority opinions, written by Chief Justice William Howard Taft, and effectively what he says is, the Fourth Amendment, it's all about the physical. It's about physically entering someone's home. It's about physically entering someone's office. It's about physically looking at their materials or seizing their person or their papers and effects. And here in this case, there was no physical trespass on Olmstead's property. They'd gone on the public streets, underneath the public streets, to tap those lines. They got in the basement of an office building that Olmstead doesn't own to tap these lines. So effectively what the Supreme Court says is, when there's no physical trespass, when nothing physical has happened to Olmstead, his persons, houses, papers, and effects, there's no constitutional violation. And so Taft argues the founding generation links the Fourth Amendment to the protection of property rights, and he argues that the Supreme Court should do the same. So it's a pretty straightforward opinion and application of the Fourth Amendment. But then we have this really interesting dissent written by Justice Louis Brandeis. And what he does is he sets out a real challenge for the Supreme Court going forward, and one that would prove deeply influential on the court and how it approaches the Fourth Amendment. Again, this is a reminder. Read all of the court's opinions, because sometimes the dissents really, really matter. And Justice Brandeis says this case presents one of the most important and difficult questions in constitutional law, which is, how do you take the text and principles written into the Constitution many years ago and apply them to new contexts, especially new technologies? And what Brandeis said is that the challenge here with the Fourth Amendment is that we want to be able to protect at least as much privacy now in 1928 as the founding generation was able to protect when it wrote and ratified the Fourth Amendment. And so here's Brandeis's powerful language. Progress of science and espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without physically intruding into the home, may extract secret records and introduce them into court. Here, Brandeis is thinking about cloud computing.
If he only knew.
Just like a century earlier. It's just an amazingly prescient opinion. And then he says, at the time of the framing, a far smaller intrusion, the general warrants that sparked the American Revolution, here he's talking about James Otis, were held to be unconscionable violations of liberty. Can it be that the Constitution does not afford protections against similar invasions in light of new technology? So again, it's a 5-4 decision, but Olmstead loses, and Brandeis is on the losing side of this case.
It's such a fascinating, I'm glad that we used phones as the examples for all of these, because this is the new technology that the founders never could have imagined. And our phones now, like you said, are so different from the phones of 100 years ago with this case. And so, technology is always adapting and, kind of looking at that, like, how do you interpret the Constitution? Is it like that, what does that, what does that protection include in the 20th century, in the 21st century? It's really a fascinating, journey to look at. So I'm like I said, I'm so glad we used phones. So speaking of phones and telephones, let's talk about Katz versus United States and the telephone booth. So for our students who might not know what a telephone booth is, Tom, what's a telephone booth?
Yeah, so it used to be the case that there were, even when I was younger, we used to have these phone booths all around. And so I wouldn't have a cell phone. If I had to call my parents or something like that, I'd have to enter one of these booths, put a quarter or whatever into the phone and make my call. What I could do, and you can see here, is I could shut the door of the phone booth behind me if I really wanted some sort of privacy. But this is what we used before we had cell phones.
And so the facts of the case, so Katz was using one of these telephone booths, and that's kind of the crux of this Fourth Amendment argument here. So tell us the facts of Katz versus United States.
Yeah, so it's 40 years after Olmstead. It's 1967. So the government thinks that Charles Katz is running an illegal gambling business, and so that he's using a public phone booth to transfer information over to his clients. So the federal agents this time, they attach an eavesdropping device to the outside of the public phone booth used by Katz. It allows them to hear his side of the conversation. And based on those recordings, they say, well, yeah, he was actually doing it. He was conducting this illegal gambling.
Much like Olmstead, this was true. He was.
Yeah, that ends up crossing state lines. And so what Katz argues is that the government, again, they violate the Fourth Amendment by listening in on his conversation without a warrant, to which the government says, look, Katz, read Olmstead. We didn't violate anything physically of yours. Here, you're in a public phone booth in view of basically everyone in the public. All we're doing is making sure that we can listen in on your public conversation on this public phone booth. But in the end, the Supreme Court agrees with Katz. Olmstead lost, but Katz wins. And in the process, the court overrules Olmstead and its requirement of a physical trespass. So the famous line here from Justice Potter Stewart, who wrote the majority opinion, is the Fourth Amendment protects people, not places. So the court rules that Katz was entitled to Fourth Amendment protection for his conversations, and that a physical intrusion into the area he occupied wasn't necessary to bring the Fourth Amendment into play. So although a public phone booth, it's in a public place, not on private property, individuals have a strong expectation that such conversations are not going to be overheard. And how do we know that Katz thought that was the case? Well, when he got into the phone booth, he closed the door behind him. So the court makes a big point of that, sort of bringing in sort of a code of privacy around him by the very act of how he used the phone booth. And so that's the Supreme Court, in the end, overruling Olmstead. But here's another case where we see an important separate opinion, which is a concurrence by Justice John Marshall Harlan. And so here in his separate opinion, Harlan says that the Fourth Amendment protections apply whenever the individual has a reasonable expectation of privacy. And so this is the test the Supreme Court's going to adopt in future cases to determine whether the government has conducted a search that can trigger Fourth Amendment protections. How does the test work? There are two parts of it. One, did the individual have a subjective expectation of privacy? Did the individual actually think that they had privacy in that context? Here, that's Katz closing the door behind them. And the second is, was the expectation of privacy one that society would recognize as reasonable?
I love when the justices do that, when they give us a clear test, like, question, answer, because it helps us when we're like reading these cases and then looking at future cases, kind of make that determination. All right, so students, let's go back to that because we only have a couple minutes left. So we're going to go back to that hypothetical that I asked in the beginning, which I said was about Carpenter, the United States. Like Tom says, this involves cell phones. So much more technology you're going to recognize. This is from 2018, and their cell phones, a cell phone like you or I would have. And so the question is, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data and location information? So think about what you've learned and what your opinion was at the beginning, and if you've changed your mind based on the constitutionality of this question. And Tom, tell us about this case.
Yeah, so I mean, this is Carpenter police officers. They arrest 4 men in a string of armed robberies. One of these men, he confesses. He gives his cell phone over to the FBI. The agents then look through the cell phone numbers of many of his accomplices, and they use this information in the suspect's call log to get cell phone records of many other suspects. So importantly here, for our purposes, the government didn't get a warrant in this case. Instead, they requested all of this data through a national law passed by Congress known as the Stored Communications Act. And so by using this law, the government only had to say that these cell records were relevant to a legitimate criminal investigation. And this relevance standard, it's lower than the test for getting a warrant known as probable cause. So the police get this information. They eventually arrest Timothy Carpenter based on geolocation data that they get from cell phones, seeing where the accomplices were at various points in time. And Carpenter himself is convicted and sentenced to 116 years in prison. So it's a really serious and long prison sentence. And Carpenter then asked the question, can the government do that? Can the FBI access my cell phone records without a warrant? And so that's where our hypothetical comes in. In the end, it's a really closely divided case. So the Supreme Court divides 5-4. The majority opinion, it's authored by Chief Justice Roberts, and the Supreme Court rules that the practice of acquiring cell phone location information from a cell phone company is a Fourth Amendment search. And so why? And so Roberts says because it violates a person's, quote, legitimate expectations of privacy and the record of his physical movements. So here we see an application of CATS. And effectively what Roberts is saying here is that, this information you can get from your cell phone records, this location data, it is so pervasively violative of property that in the end, we think the government should have to go get a warrant before it gets access to it. And here, there's some great quotes by Roberts where he says, it's a sweeping mode of surveillance that gives the government the power of near perfect surveillance, as if it had attached an ankle monitor to the phone's user. The surveillance is, quote unquote, detailed, encyclopedic, and effortlessly compiled. It provides an all-encompassing record of the holder's whereabouts. But again, Roberts writes the majority opinion, but we also see 4 dissenters in this case. And so, and they each write separate opinions where, Justice Kennedy walks in and he says, look, we already have rules that apply in cases like this. We've said for bank records, for other forms of telephone records, that the government doesn't need to get a warrant before accessing those records, that people freely give up that data to private companies, and therefore they lose all Fourth Amendment protection. And Kennedy says that these records here are a lot like those records, so we should apply those old cases to this one. And so that's effectively what Kennedy's saying. Justice Thomas steps in and he really looks at the property interests in this case. And he says, what we have to ask is, who do these records belong to under the law? And what Thomas says is, it doesn't belong to Carpenter, it doesn't belong to the cell phone user, it belongs to the cell phone company. And therefore, there are no Fourth Amendment protections for a user in this context. Justice Alito writes a separate dissent. And what he says is that, effectively, we're departing from longstanding precedent. We should apply it here. And under that longstanding precedent, someone like Carpenter should lose. Finally, Justice Gorsuch writes a separate dissent, and it's a really thoughtful one, sort of probing the limits of each of the proposed approaches while offering some of his own tentative thoughts, basically saying that I'm still learning on this issue, and that over time, maybe we'll come up with an approach that really works for all of us. So it's a really interesting case. And again, it's fun to go from prohibition to a phone booth to finally cell phones and cell phone location data.
Yeah, and it just shows, the fact that there are 4 separate dissenting justices with 4 separate reasons just kind of shows all of the different elements at play here. But like you said, ultimately in Carpenter, they did decide that this kind of broad sweeping so much information about this person's movements and interactions was kind of collectively constituted that Fourth Amendment violation. That's how I'm understanding it?
Yeah, so because of that, it is a government search. And because it's a search, the government generally must go get a warrant.
Okay. And once again, that big idea, before the government can search or seize your home, or search your home or seize your property, it needs that good reason with that warrant. All right. Thank you so much, Tom. It doesn't look like we have too many questions in the chat today, but if you did have any questions, let us know. You can come back at 2 o'clock. We'll get into a little bit more about that third-party doctrine at 2 for the advanced class. And again, once again, sorry we started a couple of minutes late, but thanks for sticking with us for an extra 2 minutes. And thank you, Tom, for kind of leading us through this Fourth Amendment 101.
Thanks so much, Jenna, and thank you everyone for being here.
Yeah. Bye, everybody. Yeah, no questions in the chat, so.
Okay, great.
Pretty quiet group today. Oh. All right, well, thanks, everybody. We'll see you at 2.
All right, bye, Jenna. See you, everyone.